The following segment is sponsored by LawCall.
This is NBC 15 Law Call.
Hey everyone, welcome to Law Call. I'm Andrea Ramey. Joining me is personal injury attorney Bill Eiland with the law firm of Eiland and Ritchie. And I know when we say personal injury, folks usually think car and truck accidents, but you also do a lot of slips, trips, and falls cases. We'll get to that in just a moment. Right. But during football season, we do these condensed versions of Law Calls. So just let folks know how they can get in touch with you, because we are limited on how many questions we can take tonight.
Sure. Tomorrow morning between 9 and 10, you're more than welcome to call our office about any topic. It doesn't matter. And truth be known, you can call after 10 or on a Tuesday. It's just during that time, between 9 and 10, all of our staff, all of our lawyers are basically waiting anxiously by the phone to try to help anything, or help you with any question that you may have, whether it's divorce, bankruptcy, real estate. It doesn't matter. And if we can't help you, then we'll try to get you to someone that can help you. And then every Monday at noon, during the noon news show, I'll be here in studio live, taking your questions live. And there's no particular topic. You can call about any question, and just another way for us to be able to get you some information that you may need. All
right. Well, our topic tonight is slips, trips, and falls.
Right.
And these are difficult cases. How do you prove that the person who was injured, that it was the property owner's fault?
Yeah, these are, in my opinion, and some people may disagree with me, but these are, besides medical malpractice, these are probably some of the most difficult cases, because you have to show that the business owner did something. Just because you have a fall in a store or at someone's house does not mean for 1 second that they're at fault. You have to show that they were somehow at fault, and you see the graphic there. A business owner is liable if they caused the unsafe condition, such as they mopped without putting warning signs. They knew about a unsafe condition and didn't do anything. I've had cases where there's been spills at a restaurant, and they've told the manager, and the manager says, "Oh, I'll get to it later," and then 20 minutes later somebody had a horrible injury. And then the last is that they should have known about it. In other words, that the condition, whether it be a broken step or water on the floor or milk on the floor or whatever, that they should have known that that was going to be a problem, and yet they did nothing about it. Now, a business owner is not liable on a few things if the unsafe condition was open and obvious. In other words, if you're walking down the aisle and you see a big puddle and you decide you're going to walk through it anyway, that you'll just tippy-toe through it and you'll be fine, well, you're not going to have a case, because you assumed the risk, and that defective condition was open and it was obvious because you could see it. So, in other words, these are difficult cases. I would highly, highly advise not speaking to an insurance company. Don't speak to whether it's the insurance company or the store or whoever it is, without speaking to a lawyer first, because these adjusters are trained professionals. They have questions that they can ask that there's really no right answer to.
All right, let's get to the phone lines. We've got Eldon on the line.
Yeah, my fiance, she worked in the school system, and she was in the cafeteria, and they had a spill. The custodian mopped the spill up, but then put down a wet floor sign. Okay. And she slipped and fell and hurt her back, and she's on the worker comp. Mm-hmm. And I'm just trying to see if you think she might have some kind of case, something she can do with the water school system.
Right. Okay. Typically in a situation like this, unfortunately, if we're talking about a public school or any governmental entity, you're going to be just basically left with workers' comp. You can't sue the custodian, because that is I'm assuming that's going to be a co-employee, and under state law, you can't sue your employer for negligence, and you can't sue a co-employee for negligence. So you may be just stuck with workers' comp, but speak to a lawyer, find out, because there could be a third party, some type of service that's doing the mopping, and maybe you have a case.
All right, that's going to do it for us. We're out of time. Thanks so much for watching, everyone. We will see you next Sunday night.